And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for this week's Law and You. It's your opportunity to get free legal advice between now and 9:30. That's 10:30 Tweed Coast time. All we want you to do is ring that telephone number, 55208888. The number again, 55208888. If you're south of the Tweed River, which is getting wider and wider, it's, of course, 07 in front of the number. But otherwise, north of the Tweed River and up through Queensland, just 55208888. Don't forget, of course, you can use our email address, which is talkback@4crb.com. If you're wanting to email a question in now, we'll deal with it on next week's program, because it's not really possible to receive the emails, read them, and then deal with them while we're live to air. So if that's okay, you can send your question in to talkback@4crb.com, and as I say, we'll deal with that question next week. Thank you to all the people who called in last week to make for a very interesting program. What a difference a week makes. It was very, very dry this time last week, and now everyone's drying out after that incredible rain that we've had over the last few days. So if you have any legal questions, if you're still inside and haven't ventured out, get on that telephone straight away, 55208888. Who knows, you could actually be our first caller for today if you call right now. Now, last week I did have a few things that I was wanting to talk about, but of course the number of callers coming in didn't make it possible to get to them. One of the things that I wanted to mention was, of course, the changes to the rental laws in Queensland that have been mooted by the Queensland government, and which have certainly brought some very adverse reaction from people who own investment properties that they're renting out. One of the major ones, of course, is that if you have a fixed term tenancy, so in other words, if you enter into a rental agreement for, say, 1 or 2 years, at the end of that tenancy, it will no longer be possible for you to simply require the tenant to leave without reason. And the law is going to be changed so that you can only require the tenant to leave if you're selling the property, if you're going to do some major renovations to it, or perhaps you might be moving into the property, but there will certainly be reasons required. It's also going to be more difficult to refuse a tenancy because someone has a pet. And basically the suggestions are that these changes are going to adversely affect a lot of young people and contract workers as far as their ability to obtain a tenancy is concerned. And there's a real prospect that it, or suggestion that it may in fact lead to an increase in rentals. So that's a bit of a concern. So just bear that in mind. The laws haven't been passed yet. The government is still considering them, and I believe that there have been submissions made in relation to it. I think there have been about 8,000 letters that have gone in from landlords who are opposed to the changes. So still a lot of debate to be had in relation to that. But the Law and You is the program. 55208888 is that number. Very quiet this morning, so if you have a question or a query, please don't leave it for the last 5 minutes of the program, when invariably we do get a bank up of calls. If you'd like to be that very first caller, get on that telephone right now, 55208888. One of the other things I have also been trying to talk about for the last couple of weeks are the changes that are coming in Queensland to the Powers of Attorney Act, or the Power of Attorney Act, which governs enduring powers of attorney and advanced health directives in Queensland. A few of the notable changes that are going to come in as a result, and this all comes into effect on the 1st of March, so it's not far away now at all. One of the things that used to concern both lawyers and attorneys in the past was if an attorney were to dispose of property of the principal without knowing that the property was in fact left to someone under the will of the principal, with the result that when the person passed away and the will is being enacted, the property that was left to a particular person, particularly if that were, say, a piece of real estate or a motor vehicle or some other personal property, for example, an art collection or something of that nature, that gift would be what we call deemed if the property had been disposed of, because obviously what is being left under the will is no longer owned by the deceased and therefore can't be dealt with. These amendments now provide that the beneficiary will be entitled to the same interest that they were entitled to under the will, and any surplus of money or other property arising from the sale or dealing with of that property. So a little bit of protection there for the attorney and also for the potential beneficiary. The legislation is also going to strengthen the requirements for capacity, so that not only will it be that the person has an understanding of the nature and effect of what a power of attorney is, but there is also going to be a positive requirement that they have freely and voluntarily entered into the document. I mean, it would seem to me to be common sense that that in speaking to someone who is entering into a power of attorney, the question would also be asked, are you entering into this of your own free will? And obviously if a person were to say, no, I'm being coerced by someone to do it, then you wouldn't proceed with doing it. One other interesting thing is that the legislation is now going to limit to 4 the number of attorneys that can be appointed jointly. I can't understand why anyone would want to appoint 4 attorneys, because it's hard enough to get any number of attorneys working together, but nonetheless there is now a limitation of 4. There have been some fairly major changes in relation to conflict transactions, which of course are transactions which permit the appointed attorney to deal with the property and assets of the donor of the power of attorney or the principal in circumstances where it might provide a benefit to the attorney or to a relation of the attorney. So those transactions, the wording around what transactions are and are not permitted is being strengthened to make it very clear. The Act is also going to allow the principal, if they still have capacity, to actually retrospectively authorise a conflict transaction that may have been entered into in error where the power of attorney didn't actually permit it to be done. So they're just a few of the things that are coming. The QCAT is going to be given greater powers to deal with failure to comply with the obligations of an attorney, and they'll also be able to appoint an administrator where an attorney appointed under a power of attorney has gone missing. So they're just a few of the things that are coming under that legislation, and as I say, that will all become effective on the 1st of March, which is coming up very quickly. This is The Law and You. Our telephone number 55208888. Very quiet morning this morning. No calls online at the moment, so if you have a question or a query, give us a call right now, 55208888. We'll be back after this word from our sponsor.
If I asked you, do you want to move into a nursing home? I bet the answer would be no. And that's fair enough. We've all heard the stories. But what if we turned aged care on its head? Imagine a place that gives the power back to the resident. You'd have your own apartment, your own furniture, you'd bring your pet, you'd be cared for, and you'd call the shots. Well, Odyssey Private Aged Care is exactly that, plus loads more. I'm Phil, and I'm proud to say Odyssey is opening soon in Robina. Search Odyssey Robina online or phone 551 6720.
Another sponsor.
Harvey Norman South Tweed deliver anywhere and they guarantee to beat any genuine competitor's price. And if you want good old-fashioned service, then Harvey Norman South Tweed is the place to shop. Their specialised staff will give you the best advice for your needs. With a great range of computers, furniture, bedding and electrical, there is no need for you to shop anywhere else. Why don't you go and see the friendly staff at Harvey Norman South Tweed, because customer service is their priority.
Another sponsor.
And this is The Law and You on 4CRB. Our telephone number 55208888. That number again 55208888. If you have a question or a query, still no calls online, so you'll get straight through if you need some legal question answered for you today. Quite often we have questions that arise on 4CRB in relation to challenging of wills and what are basically the steps that need to be taken if you're going to challenge a will. The first and most important thing is to make sure that you come within the class of persons who would be entitled to make a challenge to a will, and that would be that you are the spouse of the deceased, that you are a child of the deceased, or you are someone who was financially dependent upon the deceased at the time of their passing. They are the people who are entitled to bring what's called a family provision application, but there are other circumstances where claims can also be made on an estate. For example, if you were a beneficiary under a previous will of the deceased and they've made a new will which has excluded you, then you may be able to challenge the will on the basis that the later will was made under duress, or that at the time that the deceased made that will, that they did not have the requisite testamentary capacity to make it. And there have been a number of challenges to wills in those circumstances in recent times, cases that I've read. So just something to bear in mind. But enough of that. We've got some callers online, so we'll say a very good morning to Stuart. G'day, Stuart. How are you today?
Very well, thank you. How are you this morning?
I'm well indeed. Great to see that rain, but also great to see it easing off a little bit.
Yes, it is. We need it everywhere we can. John, I'm trying to learn about the potential problem with shares being passed from an estate, if and when that happens.
Yes.
I have an in-law who, I don't know how many years ago, bought quite a large quantity of CBA shares when they were about $5.
Mm-hmm.
Now, I understand, by the way, they have 4 siblings, but what's happened is that for many years they got the shares, instead of being paid a dividend, they were increased the number of shares, whatever that's called.
Yes, they had I think it's called the dividend reinvestment program, so they would take shares instead of dividends.
Yes, okay. Now, we understand that when they come to be distributed, that there is a capital gains put on them.
Well, in the first instance, if the shares are transferred to a beneficiary, then there would not be any capital gains, but the person who inherits the shares would inherit the cost base of the deceased. If the shares are sold in the estate administration process and the funds are distributed as cash, then definitely there would be capital gains tax payable at that point in time.
My question is on what number of shares. For example, and I pick a figure, if they had 2,000 shares at the old $5 and over the next 20 years they were increased, the dividend capital gains increased on the original quantity or on the quantity in which they were invested?
Well, they actually record the cost base of all of the shares. So the original lot of shares would have a cost base of $5. The dividend shares would have the value accorded to them at the time that the shares were allocated under the dividend reinvestment scheme. So if at that time the shares were $20 and the person instead of receiving their dividends of say $2,000, they got 100 more shares, then those 100 shares would have a cost base of $20 and so on and so on. So that's why it's very important to keep a record of when shares have been purchased and or allocated, so that those records can be kept for not only for the deceased during their lifetime in case they sell any of their shares, but particularly when you're going to the next stage, which is those shares being passed on under your will. Okay. All right?
I do appreciate that. And
no trouble.
One final thing from it, if you've got time, what does that affect if they're sold in a lump sum and it goes into their estate, and it increases from the figure that the shares are able to come. At what stage and how is the tax on the capital gain?
Well, it's worked out on each parcel. So if there was originally 2,000 shares acquired at $5 and they're sold at $100, there'll be a capital gain there. If they've then picked up, say, another 1,000 shares as dividend reinvestments over that period of time, and they've got so many shares per year, again, their cost base is applied to those shares on sale. But they're real. Stuart, you'd probably be best to ring Finance Forum on Thursday morning if you have more queries on this. What I've told you now is just very much general advice, but if you want to get into the specifics of it, I'd suggest you ring them. It's probably more appropriate for them to answer your queries. All right, then?
I really do appreciate it.
No trouble at all, Stuart. All the very best.
Right.
Time on 4CRB, 21 and a half minutes past 9, past 10 on the Tweed, and we say hello to Joanne. Good morning, Joanne. How are you today? Joanne, are you there?
Hello.
Yes, Joanne. How are you?
Well, good, thanks. Thanks for taking my call.
No trouble. How can we help?
I'm just wondering, you talk a lot about people contesting a will and the procedure and who is entitled. What if you are the executor and the person contesting the will, you agree with it? Does it still have to go to court, and does a higher body have to agree, or
well,
party?
you're in a bit of a dilemma if you're the executor, because the executor has an obligation at law to uphold the terms of the will. And so, therefore, that's the primary objective or responsibility of the testator in these circumstances. However, if it's quite clear that someone should have received provision and hadn't, then obviously what needs to be done is to work out what's going. And if it's quite clear that the person contesting the will is going to go take the matter to court, which means there's going to be court costs and all sorts of things involved, obviously it's in the best interests of the estate to look to settle the claim. Now, the executor should only settle the claim with the agreement of the residuary beneficiaries, because at the end of the day it's going to be the residuary beneficiaries whose share will be diminished in settlement of the claim. So say, for example, you've got a situation where a parent makes a will, has 3 children, leaves the estate to 2 of them and completely excludes the 3rd child, and there was really no reason why that 3rd child should have been excluded. Maybe mum or dad didn't like the religious beliefs of the child and therefore excluded them. In those circumstances, the other 2 children very well may say, look, we don't want this to go to court. It's quite clear that our sibling is going to get something, so we would rather negotiate a settlement. So the executor could very well be on board with that, but if at the end of the day one of the beneficiaries steadfastly refuses, then you've got a problem. But in those circumstances, the executor would then be seeking indemnity from the beneficiary who's refusing to settle, and saying if the matter goes to court and the court awards a part of the estate, then you are to indemnify the costs for failing to agree to the settlement. All right, then.
So say your first scenario was the one, the two children and the 3rd. So if the 2 beneficiaries do agree, is that then classed as gifting, or?
No. Well, the way it could be dealt with is that you could do a deed of settlement between the parties to say, in the interests of avoiding the matter going to court, the parties agree that this is how the estate will be distributed. If it's involving perhaps real estate, then you very well may need to get the sanction of the court, because that will perhaps cure any stamp duty problem that may arise. If it's simply cash, then that's an entirely different kettle of fish. But certainly the money that the 3rd beneficiary receives is in fact a gift under the will. There's no question about that. But Joanne, we'll have to leave it there because unfortunately we've got another few callers online. And the time, 25 minutes past 9, as we say hi to Bob. G'day, Bob. How are you?
G'day, how you going there, John?
Going well indeed. How can I help?
John, I've got a vintage one for you.
Sure.
The great-great-grandfather selected a block of land in northwestern New South Wales.
Mm-hmm.
And his will, he says, I leave my will to the oldest grandson, right?
Mm-hmm.
And the oldest grandson got and in his will he said, under no circumstances this block is to be sold. It is to be passed on to a family member.
Mm-hmm.
So the grandson got it. He goes away to the Second World War, comes home, marries a woman with a child,
Mm-hmm.
and and of course she gets the will and gets the block of land, and they sell it.
Mm-hmm.
And the daughter is now still alive and probably reasonably well off.
Mm-hmm.
Is it worth chasing up that old will and see whether we can get any money back from them and put it back into the family?
Well, the only way that could happen is if there was some trust created under the will, and if she's sold the land, it sounds to me like the property went to the eldest grandson. He then, under his will, left it to his wife, and she's sold it. So, quite frankly, Bob, I don't think there's much hope of doing anything there at all.
Right, okay.
All right, then.
Okay, thank you very much.
Okay, Bob, all the very best. And we say a very good morning to George. G'day, George. How are you today?
I'm well, John. Thanks. Yourself?
Good indeed, thanks, or well indeed. How can I help?
I have a commercial property in the Rang, and the tenant hasn't been paying the rent. And I've had some legal advice, and I've tried to move him on, but I don't think I've had really good advice. What is the law regarding the removal of the tenant? Have I got to get a warrant of possession from a magistrate?
Have you got a lease in place?
Yes.
Okay, and the lease provides a certain period of time for notice for non-payment of rent?
I guess it does. There's a little complication in there, in so much as the original lease I had with this company was in one guy's name, and I think he leased it out, and I signed another lease with another person, but it's still it's still selling the same product. I believe that the original lease formed a franchise.
Right. Okay. Well, your contract is purely governed by the lease. So whatever the lease is over the property, whoever's name that is in, that is the person who is responsible to you for the rent. So non-payment of rent, normally it will provide that you need to give 7 or 14 days notice to remedy breach, and then you can give a notice of possession. And at that point in time, you're entitled to retake possession of the property. Now, if you can get into the property and change the locks, then you're legally entitled to do that. The only problem you may have is that if the tenant comes and breaks back in and retakes possession, you've got a bit of a Mexican standoff. So, George, what you really need to do is get some good advice from a lawyer who deals in this area, so that you can serve the notices. Okay,
your company deal in that?
Yes, they do. Yes, so you could ring and ask for one of the lawyers in the litigation team, and they would certainly be able to help you with that.
I see.
All right.
I see. Okay, thanks very much. Another quick question, if I may.
George, unfortunately, we can't. We're just pressing up to the news at the moment, and I've still got 2 callers online that I'll have to take off air. So if you wait on, I'll talk to you after we come off air, and then I'll deal with those other 2 calls as well. So just hang on and we'll be there in a moment. This is John Fradgley from the Bell Legal Group. It's been great to be with you this morning for The Law and You. Slow start, and then we end up with 7 callers, so go figure. I'll look forward to being back with you again next week for another program of The Law and You, but as always, until then, it's goodbye and God bless.